Welcome back to the channel. What is going on with YSL? Well, Woody done popped up at the dang courthouse and all the judges looking. But we gonna get straight into it. Looks like it's all coming out that little Woody is the cause of all of the drama that is going on and got YSL all up in the mix. Let's get straight into it. Please hit the like button, please subscribe, and definitely turn on your notification bell so when I get the drop, you get the drop. And thank you for tuning in. Let's get it.
And you spoke with Mr. Stillwell about the ongoing beef between Kenneth Copeland, Woody, and Shell Kemp.
Yes, I did.
Mr. Stillwell referred to that beef as generational beef between those two individuals, correct?
He did.
He described the situation as they shoot at Woody and his people, Woody shoots back, correct?
That's correct.
And Mr. Stillwell was concerned because he felt that people perceived him as Woody's friend.
Yes, that is correct.
And that people were now shooting at him because Woody was in custody and they could not get Woody, correct?
I think I can infer that. I'm not sure if he specifically said that, but I was of the same impression.
It looks like to me that the state is prosecuting Woody. All these witnesses they put up is putting all the blame back on Woody. But we're going to get straight into it. Little Woody's father-in-law is finna hit the stand. And it looks like he want to say some stuff, but he know Woody out in the hallway, so he ain't saying too much. But let's continue.
And what did you tell your wife?
That our house was just shot up.
And did she come to the home? Do you recall if she came to the home after receiving that call?
Yes, she came immediately.
Did anyone else come to the home after that news had been delivered?
Yeah, I had several relatives pull up. Then our kids started pulling up.
Okay. Was Deshaun Quarterman amongst the children that came to the home that evening?
Not at first, we was trying to locate her.
Okay. And why were you trying to locate her?
Because we had got word that it was a threat on her life.
Objection to the hearsay.
Sustained.
Without saying what anybody said, why were you looking for your stepdaughter at that time?
We were trying to make sure all our kids were safe.
Your Honor, that does not call.
Overruled.
You may answer the question.
We was trying to make sure all our kids were safe because our house was just shot up for no reason.
Okay. Was there a time that Deshaun lived at that home located at 88 Venera Avenue, Southwest Atlanta, Georgia?
Yes, she stayed there until she graduated high school in 2011 before she went off to college.
Okay. Would she stay there or spend the night at different times during that time frame after she had graduated?
No, she had got her own apartment.
Okay. And around what side of town did she stay on?
Over there off of by Carver Home.
Okay. And what side of town do you know that to be?
The west side.
Okay. And do you know, can you describe what relationship, well, let me ask this question. Do you know a person by the name of Kenneth Copeland, AKA Lil Woody?
Yes.
How do you know Lil Woody?
He has a child by Deshaun, which is my granddaughter.
And how old is that child?
She's 10, she turned 10 this year.
Okay. And were there ever times where Deshaun and Lil Woody would be over your home together?
Yes.
How often would you say that Lil Woody would be present at your home?
It wasn't often because I actually didn't want a lot of people at my house.
Okay. Was there any particular reason? Let me rephrase. Did you have a problem with Woody being at your home?
I had a problem because I had a daughter who had a boyfriend who wanted to spend the night with her, and I wasn't going to go and allow that.
That's fair. That's fair. Did you have any other reason to not want her? To not want Woody near your home?
Objection to relevance.
Overruled.
Could I answer your question?
Yes, you can.
Being a parent and knowing that he was a street guy, nobody want their daughter talking to a street guy. Basically, bottom line.
Okay. And I hear you say something about being a street guy. What do you have in mind when you say that?
Woody was in the streets.
Okay. When you say in the streets, do you say, is it fair to say that you are articulating that he was around people you didn't like?
I didn't know too much know anybody that he hung with, but it's just the things that you heard that he did in the street.
Okay. Just a brief indulgence, Your Honor. When the gunfire hit your home, were you impacted by any of the shots?
No, was I hurt?
Yes.
No.
Okay. Do you know anyone else in the community or nearby area to have been hurt or their home affected by the gunfire?
What's the hearsay objection?
Rephrase.
Did you see anyone else in the community injured?
No.
Did you see anyone else's home impacted by gunfire?
No, I did not see it.
Did you see anyone else's vehicles impacted by the gunfire that rang out that morning?
No.
How long did your daughter, Deshawn Quarterman, date Lil Woody?
I think they wound up separating probably like a couple of months after the baby was born because he was in and out of jail.
I'm sorry, you said after the...
They broke up a couple of months after their baby was born.
Okay. Sorry. And do you know if they ever resumed their relationship after that initial breakup?
No, they was just friends.
Okay. And I want to circle back to something you said earlier when you testified about initially hearing the shots. How do you know that the shots were an AK-47?
I'm from the projects. I know what an AK-47 sound like.
Okay. And is it fair to say that you've heard it shot on more than one occasion?
Just once again, I'm from the projects.
Okay.
Yes.
All right. And how do you know, I'm going to circle back to something you said earlier. How do you know that Lil Woody was in the streets, as you say?
He was from McKinneyville.
Okay.
As everybody know, and 30 Deep was from McKinneyville.
Do you know Lil Woody to be a part of 30 Deep at that time? Did you know him to be a part of 30 Deep?
No, I did not. I just know they reside in McKinneyville.
And when you say 30 Deep, what do you know that to be?
It was a gang. It was a group of guys that went around running their stores, running out with blue jeans.
You started to say something and it sounded like you hesitated. Were you about to say, what were you about to say?
About what?
About 30 Deep, when you said it was a group and then you hesitated. What were you about to say?
It was a group of guys that ran in and out of stores stealing blue jeans.
Is it fair to call that group of guys that do what you just described a gang?
Objection.
Sustained.
All right. Don't answer that, please. Do you have personal knowledge that Lil Woody was a part of 30 Deep?
No, I do not.
Okay. When Deshawn and Lil Woody ended up breaking up, did they continue a co-parenting relationship that worked?
As long as he was out of jail.
Okay. Did you know the group that you described Lil Woody to be around ever to be known as the Blue Jean Bandits?
I think the media gave him that name.
Hearsay.
Sustained.
Do you know the name of Blue Jean Bandits?
Sustained.
Just a brief moment.
From
Yeah. Do you know what kind of car Woody drove?
Woody didn't own a car.
Okay. Did he operate one from time to time?
You know, he had probably had plenty of people probably gave him their car, but I don't think he actually owned the car.
Okay. You earlier said that you didn't want Woody to spend the night at your home. Were there times that you found out that he did?
Yes.
And based on the frequency of him being at the house, strike that. I want to ask that question, Brandon. Have you heard of a person by the name of Demise McMullen, or AKA Nard?
I heard of a Nard.
Okay. And have you ever seen him around the area of 88 Venera Avenue?
I'm going to probably need some clarification as to when witnesses does he know the
Sustained.
Nard?
Okay.
Do you understand that?
I do understand. How do you know Nard?
I couldn't hear you.
That's not the objection, and that doesn't address the issue. The issue would be whether or not the person he knows as Nard is the other name mentioned by the prosecutor.
All right. I'll ask a foundational question, Your Honor.
All right.
All right. Do you know the Nard that you're speaking of to be one of the defendants in this case?
No.
Okay. Is that a no, you don't know for certain, or is that a no, that is not the person you're talking about?
That is not the person I'm talking about.
Okay.
The cell phone expert, he's going to put Lil Woody at Big Nut's murder scene. Let's continue.
With regards to Mr. Bradford's device that we're looking at, does he have any calls, according to the records associated with Mr. Bradford, does he have any calls that places him with a cell phone tower where that M is, or if that's a McDonald's, correct?
Yeah, there's no activity on that side of the cell phone tower.
Okay. How about Jeffrey Williams? Cell phone records? If you could look at that and just direct us to the page, I'm going to ask you the same question. How many times does Jeffrey Williams' records show that he is using a cell phone tower close to the McDonald's?
Yeah, I'm referencing the same Exhibit 532 Yankee. Just extract. So in that exhibit, page 28 would be the time period covered by the device associated with Mr. Williams.
Your Honor, can we show page 28?
Sure.
Thank you, sir.
And again, there's no tower and sector activity that would show the device to be in the vicinity of the McDonald's.
If we can go back to Mr. Copeland's records, if you can help us with the page. I think I know what it is, but just to make sure, I'd like you to tell us what page to go to.
For Mr. Copeland, device associated with him, the 5991, that's going to be page 12.
Does
Actually, page 11, I'm sorry.
Does Mr. Copeland's device according to these records, and they vary, obviously. I mean, you're telling us that. It's not GPS coordinate, here I am, it's a range, fair to say.
Correct. We know the tower and sector where the device is. So again, a general area of where the device is.
And it could be, I guess, miles away. Is that, and if I'm saying something wrong, just please correct me.
It could be on the towers in the area. Obviously, more towers, the closer the phones are to those towers. The towers that are farther apart, the more range those towers could be away from each other. On page 11, you asked about the McDonald's. This is the slide where the McDonald's is not on there, but there is a call at 7:51, which is in the vicinity of the McDonald's.
And I'm going to ask a different question while it's page 11 of that same exhibit is before the jurors. You see where the crime scene is?
I do.
Does Mr. Copeland's cell phone ever contact a cell phone tower that, in your expert opinion, could encompass that crime scene?
Yes, this 7:28 and 45 seconds, this one here. Again, we see this device was a Sprint device. We see the towers that are listed here around the crime scene. So this device here, which is used at 7:28 p.m., you can see that here. That coverage could potentially cover the crime scene and the other locations in Green Store.
Next, the state shows how scandalous the state can be. Shannon Stillwell's interview with the police gets leaked online. Let's continue.
Arrest warrants. Did you ever come to learn of any part of the report in 29 Triple Delta Papa that publicly got released?
I was.
How did that come about in terms of publicly in your report was out there?
I saw a snapshot of my police report with a picture of the victim in that case, Shannon Jackson.
Now, I'm going to approach you with what's been marked as Triple Delta Papa. Do you recognize that?
Yes, I do.
What is that?
Well, it's a snapshot of my police report that I wrote and submitted to the...
And is it any kind of social media?
Yes, the social media account attached with it as well.
Now, Sharp is going to bring it all out about why all the guys that's on trial are getting shot at. It's because of Little Woody. Let's continue.
Investigator Griffin, you spoke to my client 3 times in regards to this incident, correct?
That's correct. That's
all right. You viewed him as a...
Yes, absolutely he is.
And you still view him as a victim?
I still do.
Okay. And on direct, you relatable. In these interviews that are all recorded, you treated Mr. Stillwell with respect, did you not?
I believe so.
Okay. And Mr. Stillwell treated you with respect, correct?
Yes, he did.
You tried to be kind to Mr. Stillwell.
Yes, sir.
I want to talk to you about the facts as you them based on your investigation and what Shannon told you in that interview.
Yes, sir.
We're talking about Miss Duncan, Shannon Stillwell, who you referred to as Shannon Jackson.
Yes, I apologize.
In a gray SUV, correct?
I think the color is actually green. It can be mistaken as gray.
Okay. And what make and model is that car?
Mountaineer.
Okay, that's fine. So they're in a Mercury Mountaineer during this incident.
That's correct.
As you understand it, the lead up to this incident is and had at that time a daughter together, correct?
That is correct.
Okay. And as you understand from your investigation, the plan was for Duncan to come pick up Shannon, and Shannon was watch the baby at his grandmother's house, correct?
That is correct.
And his grandmother lives, I don't want to give addresses, but
I don't remember, but if you say that's what it is, I don't remember. I'm sorry.
Okay. And so, asked Ms. Jones to drive her to pick up Shannon on Lakewood Avenue. And Ms. Duncan and Ms. Jones are friends or knew each other prior to this incident.
That's also
Ms. Stillwell know Ms. Jones prior to this incident.
as he explained it to me, he did not know Mrs. Tiara Jones.
Okay. Miss Duncan and Miss Jones is driving her green SUV. Put in the stop at JJ's Fish. Was it JJ's Chicken and Fish?
Fish is the
JJ's Chicken and Fish at the corner of University and Pryor, correct?
That's correct.
All right. So at JJ, you learned from Shannon that he saw Bobby Hardy. I think he referred to him as Oak.
That's correct.
And I just want to correct you. I think you said Jamal Ward. You meant Jamal Baines, correct?
No.
Oh, it was Jamal Ward?
That's correct.
Also Merle?
Yes.
Okay. At that location.
1192 Pryor. That's correct.
And he saw going in and out.
I think it was in and out of the Chevron, and then back and forth to the car and inside the Chevron.
And he took note of their presence, but he had no interactions with them at all.
Did not have any interaction with them.
Okay. And you were able to obtain the surveillance video from the parking lot of the JJ's Chicken and Fish.
That's correct.
And the surveillance video corroborated that information.
That's correct.
Okay. So, your understanding, Mr. Stillwell goes into the store, orders the food that he's going to take back to his grandmother's house.
That is correct.
Okay. And at some point, the red Camaro leaves, takes a left. Could you do me a favor? Could you put the map up again, please? Thank you. Yeah, no, it's fine. while they're working to help me. On the surveillance video, a black.
Correct.
Okay, and it is an older model black sedan. And on the surveillance video, you tell me, was it interacting with the red Camaro?
Interacting in the sense that people got out and going back and forth. I don't recall. I don't think that's what I saw.
Okay. At some point on the surveillance video, and according to the witness statements, that red Camaro, while Mr. Stillwell, Miss Jones, and are still at the JJ's, takes a left out of and goes south on Pryor, correct?
That's correct.
Okay. And maybe 20, 30 minutes after that car left, driven by Miss Jones, the SUV, the green SUV, takes a right out of the JJ's parking lot to head north on Pryor.
That's correct.
Okay. And this route that's depicted on this map is depicted on this map is what is this outline? What is that depict exactly?
Yes. I'm not sure if you told me, but
well, is that a route that you drove, or is that your understanding of the route that the SUV driven by Miss Jones drove?
no. So this is not the route of the SUV. This would be the route of the red Camaro.
Okay, all right, okay. Thank you for that clarification. So the route is not the route that the SUV driven by Miss Jones drove.
That is correct. I can show you if you'd like me to, but
okay. The bottom line is your understanding the SUV was eventually to Mr. Stillwell's grandmother's house.
If I'm not mistaken, I thought it was going to his house. I think they had a disagreement, but I thought he was going to go to his apartment after they got the food, which is back on the over there Four Seasons. I think that's what I noted in my police report.
Okay. All right. Do you disagree that? And I don't want to talk about specific addresses, but gave you, Mr. Stillwell gave you the number of his grandmother. He lived with his grandmother.
If I think on 2 different occasions, yes, he told me he lived with the time. He told me he was concerned about getting his house shot up and his grandmother because he lived with his grandmother. But I am of that opinion initially, yes.
Okay. So your understanding is this SUV is traveling in the direction. Miss Jones is traveling a route that was being dictated to her by Miss Duncan.
That's
correct. And in this route, suddenly a car speeds up this SUV that has Mr. Stillwell in the back.
That is correct.
And the engine's revving.
That's correct.
Okay, and there's high definition lights. And Mr. Stillwell was the same car he saw in the parking lot of the JJ's.
That's correct.
Okay. And then immediately, well, almost immediately after speeding up behind.
That's also correct.
Okay, and there's about 20. The green SUV that Miss Jones, Miss Duncan, and Mr. Stillwell are in from this car that's speeding up.
That is also correct.
That is hit in the rear. What do you say, the rear lift gate?
Like the rear lift gate, that's correct.
Okay, and also the back windshield shatter.
That is correct.
And according to Mr. Stillwell, the car starts to roll and flip multiple times. Of course, sadly, you know through your investigation that the driver of the SUV, Miss Jones, was hit in the face with one of the bullets fired from the car behind it. And she lost control of the car.
She did.
Mr. Stillwell told you, finally stopped flipping over multiple times. He couldn't breathe. And Miss Duncan had her injuries, and sadly Miss Jones was deceased. The defects that you observed, you took note of the defects in the car.
The ones that I took note of, they were on the rear.
Okay. And that is consistent with the information that Mr. Stillwell gave you?
Yes, it was.
Okay. You collected shell casings?
I think approximately 12.
12 shells? From what kind?
The caliber was a 7.62 caliber.
Okay. And the gun that you found on the scene is 7.62 caliber ammunition?
That is correct.
There was no other shell casings found on the scene from any other guns?
No other shell casing, just the ones that I mentioned.
There is absolutely no evidence at all any shots were fired from that green SUV, is there?
No evidence.
And you, in fact, not only collected from the JJ's parking lot, but you drove the route and looked for, were they city-owned video cameras on the street?
I found out they were owned by the city, that is correct.
Okay, how many different cameras?
I'm not certain of the exact number. I might have mentioned it in my police report, but I did take note at that. I thought were security cameras or traffic cameras at that intersection of Milton.
Okay, and there's also a traffic light at Milton and Egg area, correct?
That is correct.
Okay. And so, spend your time looking for these surveillance cameras?
Well, again, there was not a lot of people who happened or even saw it, so I have to rely on cameras or, of course, the testimony of the witnesses.
Did you view that as? I want to make sure you did collected all video in a timely manner.
Absolutely.
All right, great. Okay. Dangerous by the three people and the three victims in that green SUV. Miss Dunn in the passenger seat suffered a fractured leg, correct?
That is correct.
And that was a car accident, the car flipping multiple times, not from gunshots.
That is my understanding, it's from the accident.
My client, Mr. Stillwell, suffered fractured ribs.
Yes, he did.
Collapsed lung. You went to go see him, he had back injuries. The hospital had to actually insert a tube into his back, correct?
Well, I didn't know the last part, but I thank you for telling me that. I knew about the first two injuries.
And those were all the car flipping over after Miss Jones was shot and lost control of the vehicle.
That is my...
And, of course, Miss Jones sadly lost her life.
Yes, sir.
And that was due to a gunshot to her face. Mm-hmm. Shot from behind, behind the green SUV.
That's correct.
Okay. We established that Shannon prior to this day did not know Tierra Jones.
That is also correct.
It is true that in this interview, Shannon repeatedly expressed for what happened to Tierra. He never suggested that what happened was okay in any way, shape, or form.
No, he didn't. And I think that contributes to the reason why he was willing to speak with me.
And in fact, he requested to write a letter of remorse to Tierra Jones's family.
That is also correct.
And he did so.
He did.
Okay. You discussed a series of incidents that happened in 2015 in this interview, correct?
One in particular, I'm not sure if there was several, but one in particular.
So you discussed, he brought it up to you that someone had shot at the green store.
Yes, he did.
It grazed his forehead.
Mm-hmm.
Okay. And then he in fact told you that people came up to him and said, "You're lucky the gun jammed. Next time it's your ass." Correct?
That's correct.
And then of course there was this incident.
That's correct.
This incident, you discussed what was going on with Mr. Stillwell. Mr. Stillwell denied any involvement in the murder of Don, correct?
I don't think I specifically asked him that question. That wouldn't have been the focus of my interview. I think another detective might have asked him that I was interested in knowing.
Well, at the time of this shooting, whether you were with the gang investigators, the name Kenneth Copeland or Woody came up, correct?
That is correct.
The truth is that at the time of this shooting of Tara Jones, Woody was in custody. He was in federal custody, correct? Well, you might not know where he was, but he was in custody.
That's where he was. That is correct.
Okay. And you spoke with Mr. Stillwell about the ongoing beef between Kenneth Copeland, Woody, and Shell Cal.
Yes, I did.
Mr. Stillwell referred to that beef as generational beef between those two individuals, correct?
He did.
He described the situation as they shoot at Woody and his people, Woody shoots back, correct?
That's correct.
And Mr. Stillwell was concerned because people perceived him as Woody's friend. And that people were now shooting at him because Woody was in custody and they couldn't shoot Woody, correct?
I think I can infer that. I'm not sure if he specifically said that, but I was of the same impression.
Okay. I know further questions.
Up, little Woody's sister tells how her house got shot up because of little Woody.
Like, pull the base of it closer to you.
Specifically, do you remember if he ever had a white Dodge Charger? Now, I want to direct your attention to January 13, 2015. Did you ever have the occasion to call the police to come to your home?
I did.
Why did you have to call the police to come to your house?
Because I got a threat on Instagram.
Okay. And once you got the threat on Instagram, was there else at your home?
Say it again.
You got a threat on Instagram. Was there anything else? Was there any other reason why you called the police?
No.
Okay. Did you ever have damage to your home?
When? Before or after?
After you receiving the threat.
Okay, make it make sense, please.
Sure. Let me ask you this. Did you ever have your home shot with bullets?
Yes.
Okay. And was that around the same time you received this threat?
I got locked up.
Okay. When did you get locked up?
After I called the police.
Okay, so you got a threat, got locked up, and then you called the police?
I got a threat. I called the police. They escorted me to my grandma's house. They called me back out and locked me up.
Okay. Once you were locked up, did you ever come home and found that your home was having shot at or shot up?
Yes.
All right. How long between the time you got locked up and the time you got home? Do you remember how many days that was?
It was the same day.
The same day. Okay. When you got home, what did you find? What do you remember seeing when you came home and saw that your home had been shot up?
Bullet holes. Bullet holes.
And did you know who had shot up your home?
No.
And when the police came out to the location, did you give that information to the police that you came home and your home had been shot up?
Yes.
And prior to you going to jail, had your home been shot up?
No.
Had anything like that ever happened to your house while you were living there those
No.
8 years? I'm going to show you a few other pictures. I'm going to show you what's been admitted as State's Exhibit 3, Triple D. Were you out there when the police took any of these pictures?
No.
I'm going to show you 15 Triple D. I'm going to show you 19 Triple D. 23 Triple D. 24 Triple D. 28 Triple D. And 29 Triple D. Was that the holes and the damage that you found to your home when you came home after being released from jail back in January 2015?
Yes.
Okay. Is that everything that you showed the police back when you called the police to report that this occurred at your house?
Yes.
All right. Which one? And let me ask you, were you locked up for calling the police or were you locked up for something else?
Something else.
Okay. And what was that?
A failure to appear.
All right. I have no further questions.
DA Love gets called out on her so-called gun expert.
And Investigator Kilgore, would you tell the jury when evidence is collected from a crime scene and more than one type of shell casing is collected at that crime scene, how does the NIBIN system distinguish a crime scene with multiple different types of evidence?
Well, when we enter it into the NIBIN system, we'll enter it under the main case number. And then under that, there'll be subsets. So if you got a 9mm would be entered, a 40 would be entered, a 223 would be entered. So it would all be entered underneath that particular case number, and then they're all associated with that once.
And if, for instance, a 40 caliber shell casing collected from one crime scene produces a hit to a crime scene in Buckhead, and a 223 shell casing from that same crime scene produces a hit to a crime scene in South Fulton, will you get both of those hits on NIBIN?
Yes, when we read the results from when we enter the cartridge cases, each one will produce its own lead.
And is that what you were talking about when you talked about the subgrouping or the sub report? What is that happening? What's happening at that point?
Well, so each cartridge case that you put in is searched against the database for that cartridge case. So then when the results come back, each cartridge case, even though they're under the same set, will come back with its own result because they've all searched their own caliber subset.
Okay.
So it separates it out like that.
Actually have not seen this. Okay.
And just to be clear, if he, I don't recall him being qualified previously. If he has been, and we do have an order, because we've got orders on everything. I just don't have my binder with those. So if he has been so qualified, then obviously I would withdraw my objection in regards to that.
All right, and then what all did we need to sort out about, well, we can excuse the witness for now. We'll see you back at 1:30, please.
Thank you.
So what we were looking at now, what we were looking at were the reports that Investigator Kilgore just talked about and the entries. It's called a cartridge case image comparison exhibit information.
Okay.
That is generated in.
And are those your 588Y and 577Y?
Yes, and
Okay.
since
Which
there
one's which?
So 587Y is the report.
I thought you said five. Is there also a 577, or did I just?
You didn't make it up. There he is.
Okay.
Yes, and the 577Y is the cartridge case image comparison exhibit information for incident number
587Y is his report for all of these, or just for a particular one?
The way it works is when they get an incident report and case information or evidence from that incident report, it's specific to a particular report.
Okay.
So this particular one, 587, is for incident report number 151180462.
Okay.
And for the court's edification, I'm not going to do it while the witness is on the stand. This is for the April 28th shooting at Adele.
Okay.
And Mr. Atkins has been so kind as to find the order for the dog.
Okay.
So he's going to email it to counsel for the defense and to the court. I'm sorry. Mr. Brown found it. and
Okay,
they're
so
sending
it is an
out.
order that says, what's the date, and just tell us what it says.
The date is January 10th, 2023.
Okay.
And the order says, order permitting expert testimony from Investigator J. Kilgore pursuant to OCGA 24-7-702.
That's fine. All right, may I proceed?
Yes.
All right, Mr. Kilgore.
Yes, sir.
I've got just a couple questions for you, if that's okay.
Okay.
And you and I have had a chance to chat briefly about these reports that you have in court with you today. Is that true?
Yes, sir.
All right. So I want you to help me, if you can, to just kind of break it down. Because you've testified for a while, but I think, and you correct me if I'm wrong, that we can kind of simplify it this way. You are not a firearms examiner.
I am not.
Okay. So a person that actually looks at evidence and makes a determination, for example, of whether a particular cartridge was fired from a particular gun, is a firearms examiner. That's not you.
Correct.
Okay. In your capacity, and you work for APD.
Yes, sir.
Right? You work with their lab.
Yes.
All right. What you do, if I heard you correctly, is that you receive items of evidence tied to particular cases, right?
Yes.
Those items of evidence come into you from whoever the case agent is, the case detective or police officer, right?
Yes.
So, for example, a detective, I'm just using this name, Thorpe, might submit cartridge cases to the lab for them to be recorded, analyzed, for you to examine their characteristics. Is that fair?
Yes.
All right. You were asked on direct examination, okay, who's the suspect? What's the suspect name or the victim name or something like that? You remember those questions?
Yes.
That's not something that you do. You don't make a determination as to who a potential suspect is or who a potential victim is in a particular case that comes to you, right?
No, we only record what comes in the packaging or a submission form if it has that. We just record what's there.
Okay. So the submission form is, as you reference, when you get those items of evidence, and hypothetically I'm talking about, let's say, some shell casings, right? You would have a submission form that has those items and it has some information, usually filled out, I presume, by the detective,
Yes.
that has the name of a potential suspect, the name of a potential victim, perhaps.
Correct.
All right. You would not know whether that's accurate or not. That's just the way the information comes in.
Correct.
A detective, for example, may label someone as a suspect. Later on, may turn out that person's not a suspect.
Correct.
All right, you have nothing to do with that.
Nothing.
All right.
Okay, at the end of the day, yesterday, a letter came in, and the judge make recognition to this letter. It is from Ashley Merchant, and it's in reference to her client, Arnold Martinez Arnold Duke. And he was supposed to testify yesterday, but the state put him on hold. And she's complaining about the state, and she thinks the state, well, her client thinks the state is trying to run game and wait till she's out of town and have some stand-in lawyer to come in because he's under a plea agreement as well as Mungtung, and he doesn't want the same thing that happened to Mungtung to happen to him, where they're trying to throw him back in jail. So let's get straight into the letter. Dear Judge Whitaker, I represent Martinez Arnold, Mr. Arnold, a former defendant in the above matter. I am submitting this letter in anticipation of Mr. Arnold's upcoming testimony. The state recently advised me that the state intended to call Mr. Arnold today, October the 16th, 2024. Yesterday I was advised that he will not testify today and would likely not be called for several weeks, but that they would try to let me know by next week. Mr. Arnold originally agreed to testify when he entered into his plea in December of 2022. Now approaching 2 years, Mr. Arnold has kept in constant contact with me over these past 2 years to make sure that he would be available whenever the state might call him as a witness. The first time that I was contacted by the state about Mr. Arnold being called as a witness was on August the 13th, 2024, by Adrienne Love. Ms. Love asked if I could not appear with Mr. Arnold if there was anyone who could serve as a stand-in counsel for me. I informed Ms. Love that I was not willing to allow any stand-in counsel to stand with Mr. Arnold during his testimony, and I asked for Ms. Love to give me some general indication of when Mr. Arnold's testimony would be needed on September the 4th, 2024. The state told me Mr. Arnold was needed within the next few days. I immediately emailed Ms. Love an investigator long with a few dates for which I had leaves of absence on file for September and asked for the state to provide me with an anticipated time frame for when they might call Mr. Arnold to the stand. I received no response by email, but Ms. Love called my cell phone the evening of September the 11th, 2024, and also sent a text asking me to reach out to Investigator Long about the timing of Mr. Arnold's testimony. I responded to the same email chain providing all the dates we were available and the few dates that I was not available. Ms. Love indicated that she would be calling Mr. Arnold as a witness in September. So I wrote Ms. Love in the court about the 5 days for which I will leave in September. Mr. Arnold was never called as a witness during this time, and no one from the state ever told Mr. Arnold might be called as a witness the last week. On October the 8th, 2024, Investigator Long emailed me and copied Mr. Adam Abbott, and not Ms. Love, about Mr. Arnold's testimony. We were told Mr. Arnold will be called as a witness sometimes mid to latter part of the week, October the 14th, 2024. We were asked to meet so the state could give notice of his impending testimony. I provided a very detailed response advising the state that I could have Mr. Arnold's testify beginning October the 14th, 2024, and anytime through October the 18th, 2024, and beginning again on October the 22nd through October the 25th, 2024. Since this Investigator Long had mentioned in his email wanting to provide notice of Mr. Arnold's impending testimony, I drafted my October the 9th, 2024 letter to Ms. Love and copied all parties, including the court, to clarify that Mr. Arnold was not avoiding service of any subpoena and intended to testify if called as a witness, but that we just needed some accommodations, such as notice to ensure that I was able to accompany him for his testimony as his attorney. On October the 9th, 2024, Investigator Long emailed me that they would provide a date for Mr. Arnold's testimony within 48 hours. He also said that they would provide me with anything that the state wanted Mr. Arnold to review prior to his testimony and answer my questions about whether the state intended on asking Mr. Arnold any additional questions that would involve his Fifth Amendment privilege and or grant of immunity. On October the 11th, 2024, Investigator Long advised that Mr. Arnold would be called as a witness on October the 16th, but that they would keep me posted as the trial progressed. He also advised that Mr. Abbott would be responding about whether there were any prior statements that state intended to use to refresh Mr. Arnold's memory and avoid wasting the jury and the court's time. I previously had asked the state to send me any prior statements the state may wish to use during Mr. Arnold's testimony. On October the 14th, I wrote Investigator Long and Mr. Abbott to confirm that Mr. Arnold was being called at 9 a.m. on October the 16th and to again ask about those two outstanding questions regarding prior statements and questions outside of his proffer. In response, today, October the 15th, 2024, Investigator Long responded that Mr. Arnold's testimony would not be needed this week and that the state did not anticipate his testimony taking place in the next few weeks. He wrote further, I do not have a date certain as of now. Mr. Arnold and I have now been on call since January of 2023. While we realize the trials are sometimes unpredictable, we have been available for the past 22 months. Now, moving into November of 2024, I am specifically set for a jury trial the week of November the 18th and will be on medical leave beginning November the 22nd. Given how other witnesses have been required to testify with stand-in counsel, Mr. Arnold is very concerned that the state is purposefully delaying calling him to the stand so that he will be denied his rights to have his counsel of chosen, the same counsel that negotiated and is familiar with the terms of his plea. I am kindly asking the court to instruct the state to advise me whether in fact it intends to call Mr. Arnold at all, so that we can avoid any unnecessary waste of the parties and the court's time and resources. If the state still intends to call Mr. Arnold as a witness and to the extent potential evidentiary and privilege issues before they arise, and to expedite Mr. Arnold's testimony in the presence of the jury, I believe advising the court of the history with regards to Mr. Arnold's plea negotiation and plea agreement would greatly assist the court in ruling on potential issues. Factual and procedural history regarding Mr. Arnold's plea. In 2024, Mr. Arnold was charged in an indictment to which he pled guilty to a misdemeanor and completed his sentence on February the 29th, 2016. In 2015, Mr. Arnold was charged in an indictment to which he pled guilty under the First Offender Act and completed his sentence and was discharged, exonerated on November the 1st, 2021. Mr. Arnold was able to complete the foregoing sentence without a felony conviction on his record. Despite this, in 2022, Mr. Arnold was arrested and charged for these same two underlying criminal incidents from Cites 14 SC 131032 and 15 SC 140116 in the current RICO. indictment and held without bond in the Fulton County Jail. Despite having been able to successfully complete probation for both underlying offenses and move forward without a felony on his record, Mr. Arnold was nevertheless denied bond. Having little recourse, Mr. Arnold attempted to negotiate a plea in connection with the RICO indictment that allowed him to finally be released from the conditions at the Fulton County Jail. Notably, while the state and Judge Glanville both were unwilling to grant Mr. Arnold bond, they were willing to let him be released on probation, providing that he provide testimony sought by the state. Mr. Arnold, however, was unwilling to make all of the statements that the state sought. So Mr. Arnold was again sent back to the Fulton County Jail to languish without a bond. After further and deliberate negotiations, the state agreed to accept the statement Mr. Arnold could swear to under oath and agree to release Mr. Arnold on probation once he made those statements and agreed to testify for the state about those statements. Mr. Arnold agreed only to the specific statements set forth in his plea agreement, and he was very clear that he intended to retain his right against self-incrimination under the Fifth Amendment to the United States Constitution should any party seek to question him about any matters outside of the specific statements contained in his plea proffer. On December 16, 2022, Mr. Arnold entered his plea, which allowed him to remain on probation. A copy of the plea is attached here too. Since the entry of this plea, Mr. Arnold has been in full compliance with the terms of his probation, for which reporting is set to terminate in December of this year. The state has not suggested Mr. Arnold has not complied with the terms of his probation, nor could it. Also, as noted above, Mr. Arnold has been ready to testify within the confines of his plea agreement. Recently, the state called one of Mr. Arnold's co-defendants to testify pursuant to his plea agreement. This witness did not receive a grant of immunity for his testimony, and unlike Mr. Arnold, apparently did not retain his Fifth Amendment privilege when he entered into his plea agreement. After this witness testified, the state filed a motion to revoke his probation for what the state believed was a violation of the terms of his probation. The state alleged that the witness directly contradicted the special conditions of his plea agreement by disavowing the factual acknowledgments he had sworn were accurate and true during his plea hearing. The state then argued that this witness had the opportunity at the time he took his plea to correctly or clarify any statements and factual acknowledgement before affirming their truth under oath. Mr. Arnold has serious concerns that the state may, without any authority, attempt to do the same thing with Mr. Arnold. For this reason, Mr. Arnold wishes to advise the court in advance of his testimony which such an action by the state would be improper and illegal. As an initial matter, where Mr. Arnold attempted to correct or clarify the statement contained in his original factual acknowledgement, he was told if he did not admit to the statements or written, he would be sent back to the Fulton County Jail, held without bond, and be placed on trial with his co-defendants. Mr. Arnold continually explained that he could not swear to all of the statements the state wanted him to swear to in the factual acknowledgement. Notably, after Mr. Arnold was willing to return to the Fulton County Jail and stand trial, the state amended the factual acknowledgement to remove those statements for which Mr. Arnold had no acknowledged. In other words, the parties specifically negotiated the scope of the factual acknowledgement to significantly narrow the potential scope of Mr. Arnold's testimony, which included a separate constitutional right to remain silent. We are writing to advise the court and the state, outside the presence of the jury, that if the state intends to call Mr. Arnold and ask him questions about facts that are not contained in his plea proffer, or questions that were worded differently from the statements to Mr. Arnold's plea proffer, and then attempt to use those statements against him as it has with other witnesses in an effort to revoke his probation, Mr. Arnold will assert his Fifth Amendment right against self-incrimination and will refuse to answer any such questions. Mr. Arnold asserts of his Fifth Amendment right, however, which was specifically contemplated by the express terms of his negotiated plea agreement, cannot be used to revoke his probation or to hold him in contempt. In addition, at no time between the date of Mr. Arnold's plea and the present has anyone from the state suggested to me that Mr. Arnold will be offered immunity for any testimony he may give. Nevertheless, based on the state history of using immunity to force additional witnesses' testimony in the middle of a trial, I outline below several issues for the court consideration prior to Mr. Arnold taking the stand. Mr. Arnold has no faith in any immunity agreement that the state might put forth in this case, and which has been offered to other witnesses to compel their testimony under the threat of incarceration without assurance from the court that this immunity will extend to the state. Attempt to revoke his probation if they do not like how he answered questions. Furthermore, Mr. Arnold has no faith that the state will not use whatever he says, no matter whether he has an agreement from the district attorney for immunity against him if they do not like how he testifies on the stand. Mr. Arnold constitutionally protection, much like a promise of immunity, ring entirely hollow when the state refuses to honor them. With no guarantee that the state will not try to revoke Mr. Arnold's probation or charge him with another crime based on the same allegations, or deny him bail, or require him remain in unconstitutional conditions. Then she states the grant of immunity may not be conditioned, and therefore the state may not condition a grant of immunity on the testimony of witnesses being fully complete and truthful. And she gives some law. Mr. Arnold will only answer the questions specifically negotiated and set forth in his proffer. In other words, he is asking this court to make the state honor its agreement with Mr. Arnold and not allow the state, as it has in the past, to change the terms only after it is unhappy with the testimony. To be perfectly clear, based on the express terms of his plea agreement, the state may only question Mr. Arnold to the following. Mr. Arnold is a member of the Rolling 60 Crips. Mr. Arnold became affiliated with YSL in 2015, but not that YSL is anything more than a record label. Mr. Arnold committed the other incidents for which he pleaded guilty to in indictment, and again in 2022 in this indictment. Mr. Arnold committed the other incidents for which he pleaded guilty to in indictment, and again in 2022 in this indictment. Mr. Arnold was present on May the 9th, 2022, when a search warrant was executed, and he does not claim ownership of any of the items the government claimed to have discovered during this search. Mr. Arnold also acknowledged that YSL, which he knows as a record label, has the following identifiers: clothes with YSL or slime, pendants with letters YSL or slap, colors in green for slime, seeing YSL members use one or more hand signs, language that members of YSL use, including slap, which means slime love all the time. Some of the language includes calling each other slime. Symbols that YSL uses includes a green heart and green snake. As explained above as to any other topics or questions, Mr. Arnold intends to assert his right to remain silent under the Fifth Amendment. The Fifth Amendment protects Mr. Arnold against any statements that potentially could be against his self-interest. In the RICO indictment, the state has alleged that certain non-criminal acts were overt acts. Overt acts, where am I? Okay. overt acts in furtherance of a conspiracy. Therefore, in any statement by Mr. Arnold, even as to a non-criminal act, could be used by the state to demonstrate an overt act that could be used potentially to prosecute Mr. Arnold. In that scenario, Mr. Arnold will be forced to remain yet again in the Fulton County Jail without bond. Such an action by the state would be an obvious attempt to strong-arm Mr. Arnold into providing additional testimony. Even though the state agreed to the terms of his plea offer, knowing full well to what Mr. Arnold could testify. Therefore, Mr. Arnold intends to assert his Fifth Amendment privilege against making any such statements that are not covered in the agreed upon proffer, since any statements, as the state argues, can be used against him as any overt act, should the state seek to use the information for that purpose. And he is asking this court to uphold the terms of his agreement and to decline any invitations to interpret his failure to testify to facts outside of that agreement as evidence of violation that could be used to rearrest him. It is also my understanding that many of the questions the state may wish to ask Mr. Arnold pertain to social media posts, musical lyrics and videos, and friendships or associates he has. The state has denoted certain of these facts as overt acts and continues to argue that other acts are admissible as overt acts in furtherance of the alleged conspiracy. Therefore, Mr. Arnold tends to assert his Fifth Amendment privilege for any questions about social media posts, music lyrics, and videos, and his friendships or associations, since none of these topics were listed in his plea proffer. Despite the foregoing, Mr. Arnold wishes to make certain that he intends to fulfill the requirements of his plea agreement and testify as to the matter outlined in his proffer and summarized above, but only those topics. Mr. Arnold wants to make abundantly clear that, based on his fear that the state will seek to revoke his probation, should the state seek to testimony beyond that in his proffer, he only intends to respond to their specific questions, and only they are worded in the same manner they were posed during Mr. Arnold's Mr. Arnold's plea proffer. If the state intends inquiring any facts beyond the scope of his plea proffer, Mr. Arnold is providing the court and the state with notice that he intends to assert his right to remain silent, a right he specifically protected in his plea agreement. I trust this history of the negotiation regarding Mr. Arnold's plea and summary of Mr. Arnold's position on recent issues that have emerged in the context of other witnesses will assist the court in evaluating these issues should they arise during Mr. Arnold's testimony. We happily invite the state to outline its position for Mr. Arnold, the court, and the current defendants so that everyone is on the same page before Mr. Arnold anticipated testimony, so as to ensure his testimony can be taken expeditiously, fairly, in accordance with the terms of his negotiated plea, and without a violation of Mr. Arnold's Fifth Amendment constitutional right. Should the court wish to hear from Mr. Arnold on any of these issues in advance of his testimony, I am happy to address them at court. Pleasure. Sincerely, Ashley Merchant.